On June 15th, the predominantly conservative Supreme Court of the United States surprisingly voted to uphold ICWA, a law passed in 1978 for the purpose of protecting indigenous children by granting tribal governments exclusive jurisdiction over the children residing on reservations. And the purpose of this law can plainly be seen by its long title, which is an act to establish standards for the placement of Indian children in foster or adoptive homes to prevent the breakup of Indian families and for other purposes. ICWA was upheld on a vote of 7-2, with the two dissenting voices being that of Justice Clarence Thomas, because of course, and Samuel Alito, with Samuel Alito arguing that in his view, Congress does not have the power to sacrifice the best interests of vulnerable children to promote the interests of the tribes in maintaining membership. But the fact is that this law was passed for the sole purpose of protecting the best interests of indigenous children, especially considering that through the 1950s and 70s, about 1/3 of indigenous children were removed, often forcibly, from their homes and placed in non-indigenous homes or placed with non-indigenous affiliated organizations. And this is something that was touched on by Justice Neil Gorsuch when he said that the mass removal of children from their family homes in the 1950s, 60s, and 70s was only the latest iteration of a much older policy of removing Indian children from their families, one intentionally spearheaded by federal officials with the aid of their state counterparts nearly 150 years ago. In all its many forms, the dissolution of the Indian family has had a devastating effect on children and parents alike. It has also presented an existential threat to the continued vitality of the tribes, something many federal and state officials over the years saw as a feature, not a flaw. He then also went on to say that in adopting the Indian Child Welfare Act, Congress exercised its lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. I feel like this also touches back on a statement made in 1978 by Chief Calvin Isaac of the Mississippi Band of Choctaw Indians when he said, "Indian children are removed from the custody of their natural parents by non-tribal government authorities who have no basis for intelligently evaluating the cultural and social premises underlying Indian home life and child rearing. Many of the individuals who decide the fate of our children are at best ignorant of our cultural values and at worst contemptful of the Indian way and convinced that removal, usually to non-Indian households or institutions, can only benefit an Indian child." So if Justice Alito actually cared about the best interests of indigenous children as he's claiming, he would have voted to uphold ICWA instead of voting against like he did. Because although they like to frame that the removal of indigenous children from their communities was often for their best interests of the children, in reality it was nothing more than a tool to erase indigenous identities here in the United States. And this is why this is a win, that indigenous children will continue to be under the jurisdiction of tribal governments, who will continue to place them with people within their communities, either extended family or other members of their tribe. However, just because ICWA was upheld, this doesn't mean that the battle is over. Those who attempted to overturn ICWA will continue to push, will continue to overthrow these protections that were put in place to protect indigenous children, to protect indigenous people, and to protect indigenous sovereignty.